Worker Protection, Amendment of Equality Act 2010 Act.
Enforcement commenced on October 26, 2024. Of the 5.6 million businesses within England, Scotland and Wales, half are unaware of the new workplace sexual harassment law. The Worker Protection Act 2023, an amendment to the 2010 Equality Act, is designed to strengthen the protection of employees from sexual harassment in the workplace by emphasizing prevention. This legislation does not provide comprehensive coverage of equality and diversity issues. It is also not designed specifically for victims or survivors. In England, Scotland and Wales, an incident of sexual harassment occurs in the workplace on average every minute. 30% of the workforce in the past 12 months has experienced sexual harassment. Currently, there are just under 5,000 cases waiting to be heard at the employment tribunals in relation to sexual discrimination. It doesn't matter who you are or how you identify, any form of harassment, whether sexual or not, and bullying can happen to anyone. Just because you don't see or hear it, it doesn't mean it's not there. The Worker Protection Act 2023, a landmark in workplace safety, ushering in a new era of employer accountability for addressing sexual harassment. Addressing incidents after they occur, even when handled respectfully, is no longer sufficient. A minor infraction can have long-lasting effects and significant ramifications. Sexual harassment is a serious issue that can leave individuals feeling embarrassed and scared. While it may be difficult to speak out, ignoring it or laughing it off will not help and may even worsen the situation.
Everyone in the workforce is expected to adhere to a standard of conduct that promotes fairness, respect, and dignity for all individuals within the workplace. It is imperative to establish and maintain clear policies and procedures regarding workplace safety. These should encompass measures to prevent physical harm, emotional distress, and any other form of harm or harassment that may compromise the well-being of employees. In the event of any misconduct, including sexual harassment or violence, it is essential to take immediate action to address the situation and support the victims, while ensuring that appropriate measures are taken to hold offenders accountable. This includes treating others with mutual respect, professionalism, and refraining from behavior that may cause fear, alarm, or distress to others. Employers are now required to take proactive, reasonable steps to prevent harassment before it happens and foster an environment where everyone feels empowered to speak up.
Embedding a truly inclusive and respectful culture requires more than policies. It demands a holistic shift in habits, mindsets, structures, and processes.
This isn't a one-time effort. It requires continuous commitment from everyone, every day.
Strategies must evolve to meet new challenges and opportunities.
Moments of challenge provide organizations the chance to align their culture with their actions, reflect on their practices, and seek constant improvement.
While the legislation imposes new responsibilities, it also opens the door for organizations to build a workplace defined by positivity, communication, and mutual respect. Let us explain and guide you through the process. This Act extends to England, Scotland, and Wales. The Equality and Human Rights Commission published on September 26, 2024 the Sexual Harassment and Harassment at Work Technical Guidance. Any form of harassment or bullying must not be tolerated. Sexual harassment in the workplace is illegal under the provisions of the Worker Protection Act 2023 and must not be tolerated in any workplace. No employer is exempt from this duty, no matter the size of the workforce. Everyone in the workforce must comply with the new law. The preventative duty is an anticipatory duty. It is designed to transform workplace cultures by requiring employers to take positive and proactive reasonable steps to prevent sexual harassment of their workers. Sexual harassment of a worker can be committed by another worker, an agent acting on behalf of the employer, and a third party. Any form of harassment or bullying can be deeply traumatic for victims, causing significant harm to their health and psychological well-being.
We all have our personal boundaries when it comes to what we find inappropriate or uncomfortable. However, We can't always predict where that line is for everyone else. That's why it's best to avoid behaviour that could offend or upset others, even if it doesn't offend you personally.
You might think, but I was just having a laugh. It was just a bit of banter. Lighten up, it was harmless flirting. The truth is, intentions don't matter as much as the impact of the behaviour. When it comes to sexual harassment, the key issue is how the behaviour is perceived.
Sexual harassment is defined as unwanted conduct of a sexual nature, and that unwanted conduct can include comments or jokes, physical gestures, facial expressions, or even aggression. It doesn't stop there, the list goes on.
Crucially, it doesn't have to be the intended recipient of the behaviour who finds it unwanted or unwelcome. For example, you might make a few risque jokes with a workmate, believing they'll find them funny. But if someone else overhears the conversation and feels offended, the situation can still amount to harassment. Even if the harm caused is unintended, the effect on others still matters.
To foster a respectful workplace, it's always best to err on the side of caution. Keep your conduct clean, professional, and inclusive. It's a simple step that makes a big difference.